Hey, everybody, and welcome to the latest edition of Legal Bites, the official podcast of Cummings and Cummings Law, where we focus on assisting businesses, large and small, and their owners redomesticate out of volatile legal and tax environments like California, the formerly Golden State, to predictable pro entrepreneurship, pro growth jurisdictions like Florida and Texas. Today, I am reviewing a recent report on Realtor.com dated March 30th entitled, Here's How Much LA and Silicon Valley High Earners Could Save by Trading California for Miami. But before we get into the substance, a brief introduction. My name is Chad Cummings, and I am an attorney and certified public accountant serving clients in matters of business, tax, and commercial law throughout the states of Florida and Texas. I am Chief Executive Officer of the multi-state, multi-attorney law firm Cummings and Cummings Law. And in addition to my day job, I also teach business and tax law at the university level. I hold 4 degrees, including 2 law degrees, together with a bachelor's in accounting and a master's in taxation, in addition to 11 professional licenses and certifications covering accounting, tax, audit, and of course, the law. My firm website is www.cummings.law. Now, onward. According to this report, a luxury real estate advisor named Kevin Rutoy ran the numbers and posted them on LinkedIn. According to his analysis, a Californian earning $500,000 per year would save more than $51,000 in annual state income tax by moving from Los Angeles or San Francisco to Miami. That is not a projection, that is basic math, and that does not even take into account the lower cost of living in the Sunshine State. California's minimum tax rate at that income level is 10.3%, and it can reach 11.3%. In fact, the top marginal rate in California is currently 13.3%, the highest of any state in the country, and it is slated to rise. And that does not even take into account the new proposed California wealth tax that I have articulated in my earlier presentations. By the way, as a point of reference, Florida's personal income tax rate is 0, and most businesses in Florida pay 0 income tax as well. Realtor.com published a detailed analysis of this trend, and the numbers only get more striking when you extend them over time. Rutoy calculated that a California transplant saving $51,000 per year in state taxes, investing that windfall at 7% over 10 years, would accumulate $750,000 in additional wealth. That is a down payment on a second property. Hell, that's a whole new house in many places, and not a bad house at that. That is early retirement brought forward by years. That is the compound effect of a single decision applied over a decade. And the migration data confirms that this is not theoretical. From 2022 to 2023, the most recent years for which we have data, Florida was the top recipient of adjusted gross income in the entire country, with $20.65 billion worth of AGI moving in. California and New York led in lost income and wealth. Capital is continuing to move from high tax jurisdictions to low tax jurisdictions at a pace that has no precedent in history. Anna Bozovic, a Miami-based real estate analyst and founder of Analytics Miami, told Realtor.com that capital flows toward the path of least resistance, and that is exactly what I have seen firsthand at my law firm. That is true for individuals. It is also true for businesses. And this is where most people, including many attorneys and CPAs, make a critical error. They help their clients move their personal residence to Florida, but leave the business domiciled in California. That is a mistake with serious and compounding consequences. If you personally move to Florida but leave your LLC or corporation domiciled in California, California will continue to treat your business as a California domestic entity. You will continue to file California tax returns. You will continue to pay California's franchise tax. You will continue to be subject to California's burdensome regulatory environment, courts, and rules governing business disputes. You moved your body, but you failed to move your business, and California will notice. The best legal mechanism in almost every case for moving your business is a process known as redomestication. Redomestication is the method of transferring the so-called home estate of an existing company, which might be an LLC, corporation, partnership, or subchapter S entity, from one state to another. You keep your existing federal employer identification number. You keep your existing contracts. You keep your bank accounts. You keep your credit history. You keep your business name in almost every case. The company that exists after the redomestication is the same legal entity that existed before. Nothing changes except the state where the company is domiciled. It is also a non-taxable reorganization under the Federal Internal Revenue Code when it is performed correctly. Redomestication, when coupled with a change of personal residency and a reduction or outright cessation of business activity in California, can be an effective way to reduce or eliminate tax nexus in the Golden State. Don't take my word for it. Ask your CPA, but don't be surprised if you get a blank stare, as frankly, redomestication is a lesser known legal process. For owners of pass-through entities like LLCs, tax-just partnerships, subchapter S entities, and so forth, where business income flows through to personal tax returns, this is the mechanism that converts the $51,000 in annual tax savings from a hypothetical into a reality. Without it, California will assert that your business still has nexus in the state, and California's Franchise Tax Board in Sacramento is among the most aggressive taxing authorities in the world. They will send you letter after letter, and it will not be friendly. And the urgency is increasing. California, as I have reported in numerous of my earlier presentations, is considering a proposed wealth tax that would require the state's high earners to pay a one-time tax equivalent to 5% of their assets, not their income, their worldwide assets. Now, whether that proposal ultimately passes is uncertain. Governor Newsom is fighting to block it, or at least that's what he says. But the mere possibility has prompted some of the wealthiest people in California to act. Realtor.com reports that Mark Zuckerberg and Sergey Brin have purchased homes in Miami. They are not buying vacation properties. Rather, they are establishing residency. And when people at that level begin making moves, it tells you everything you need to know about where the tax and regulatory environment is trending. Bozovic stated it clearly in the report. What matters is not just the policy itself, but how it influences human behavior. High net worth individuals plan proactively. Even the possibility of new taxes can influence where they choose to establish their residency. That logic applies to a billionaire buying a waterfront estate in Miami as much as it applies to you and your small or medium-sized business. Now, let me address some of the alternatives to redomestication, because all three are inferior in most cases, and yet all three are recommended by professionals who do not understand this process, if they know it exists at all. Foreign entity registration, sometimes confusingly referred to as foreign qualification, keeps your company domiciled in California. You register in Florida, but you remain subject to California taxes, filings, and their infamous franchise tax. Now you manage two compliance tracks instead of one. You have saved nothing on the California side. You've just added some more Florida paperwork on top of the existing California burdens you were trying to escape. This is one of the most common mistakes I see, and it is one that costs business owners the most over time because that compounding effect works in reverse. Every year you remain registered in California with California Tax Nexus, thinking you have moved, is a year of taxes you did not necessarily need to pay. Now let's talk about option number two. Merger, or what I will refer to as traditional merger, is still sometimes necessary in some states, but not California. Traditional merger requires forming a new entity in Florida and merging the California entity into it. There is a myth floating around that California does not permit redomestication. That's false. They absolutely do. We've done a ton of them. There's another myth floating around that California only permits certain types of entities to redomesticate. I can tell you unequivocally and without reservation that California certainly permits LLCs, subchapter C corporations, and subchapter S corporations to redomesticate out of the state, contrary to what the so-called experts on Reddit or AI may have told you. But anyway, back to the matter at hand. I mentioned that because sometimes people start talking about merger and I say, hold on, slow down. This isn't 1995 anymore. There's a better way. As I said, traditional merger requires forming a new entity in Florida and merging the old California entity into it. The old entity ceases to exist. You will likely need a new federal employer identification number if you go this route, and you may trigger a taxable event, especially if you try to handle it yourself. You will need to retitle assets, renegotiate contracts, and establish new bank accounts. Legal fees can reach $10,000 or $20,000 or more for a simple merger. And a single missed consent or broken assignment clause can convert what should have been a simple administrative exercise into a business and financial disruption that can take months or years to resolve. That is not hyperbole. Now let's talk about option number three, and I use the word option very loosely here. Dissolution, also sometimes referred to as termination, although legally those are two distinct processes, but we'll just refer to it as dissolution for the sake of expedience. Now, dissolution kills the company. As I've said in some of my earlier videos, sometimes I will get on the phone with a prospective client who brags that they've dissolved their company and they want a discount because they've done some of the work for me. I hate to be the bearer of bad news, but dissolution is the death penalty. It's the firing squad. There's nothing left to move. You lose your liability protection. You lose your credit history. If legal claims surface after dissolution, and that happens far more often than you would like to believe, those claims will land on you personally because the corporate veil is no longer in existence. That means your personal bank accounts, your personal assets, in many cases, your retirement accounts, the clothes off your back, all of that could be subject to liens and attachment. Unless you are truly going out of business, and by that I mean shutting your doors, dissolution is not a relocation strategy. Now, the most important document in a properly performed redomestication is the legal plan of conversion. Without it, your filing with the Secretary of State may have no legal effect, or it may have unpredictable effects, or may result in the unintentional termination of your company. I see that all the time when people try to take matters into their own hands. And at that point, it becomes very complicated and frankly, very expensive to fix if it can be fixed at all. LegalZoom and Rocket Lawyer cannot prepare a plan of conversion because they are not attorneys. They are not law firms. They do not owe you fiduciary duties. Don't take my word for it. It's a disclaimer on the bottom of their homepage. See for yourself. And the advice from Grok, Gemini, and Claude on this process is still wrong. I checked just a few minutes ago. I check almost every day wondering if it will ever be corrected. As of yet, that has not occurred. My law firm, handles redomestications for a flat fee when there are 10 or fewer owners. By owners, I'm referring to members of an LLC or shareholders in a corporation. The entire intake process takes less than 5 minutes at my website. You can see the exact price, not a quote, the exact price, and complete the process in under 5 minutes. You heard that correctly. As an attorney and CPA, I personally prepare every document within the scope of work, file with both states in the correct sequence, and handle any correspondence and inquiries with either the Florida Department of State or the California Secretary of State during the process. And I send you weekly written status updates by email until the process is completed. And I back all of this with a 120% money back guarantee. The reason I'm able to do that is because I have a true 100% success rate to date. Let me speak a little bit more about what that money back guarantee entails. If the California Secretary of State fails to approve your redomestication and I am not able to fix it, which again to date has never happened, I will refund 120% of the legal fees that you paid to me. Try finding another attorney with that proposition. If you have questions regarding redomesticating your existing LLC or corporation, please use the link in the description for more information on this intricate process and to schedule time for us to speak about your specific situation. Again, my name is Chad Cummings, and I hope that you found this information useful. As always, the information in this presentation is general in nature, and it is not legal advice, because legal advice, by definition, must be specific to a particular set of facts and circumstances. Should you have any questions regarding this information or the content of any of my earlier presentations, please visit my firm website at www.cummings.law, not .com, but .law, to schedule time for us to speak. I look forward to that opportunity to speak with you and perhaps even work with you very soon.